Good day, Crime Talk aficionados. It's Sunday, but we have the weekly recap of all the top stories from the week of January 13th of 2025, all conveniently located in one location. That's right here. Enjoy the weekly recap, have a wonderful day, and remember, the Constitution matters.
All right, lawyer.
First, Bryan Kohberger. Finally, we're getting a little bit closer. I can feel the momentum building. We're getting to those motions hearing type things. We're getting to the expert disclosure stuff, ladies and gentlemen. It's coming. All right. So prosecutors in the case against Bryan Kohberger, obviously the man accused of killing 4 University of Idaho students, may call more than 24 expert witnesses in a host of subject areas, including DNA, cell phone, geolocation, and crime scene reconstruction to try and prove Bryan Kohberger is in fact the guilty party beyond a reasonable doubt. Now, none of the state's experts detailed to the defense last month in a sealed court filing were previously disclosed to the public. None of the state's experts provided any detailed explanation as they were filed under sealed and they've been recently disclosed to the public. But the prosecutors identified a handful that they planned to call as witnesses at trial. And in a newly released legal brief, we get a little more information. Now, the filing reads that 2 FBI agents are among the 25 potential expert witnesses for the prosecution. First is Special Agent Nick Balance, a member of the FBI's Cellular Analysis Survey Team. He is going to offer his opinion about where investigators allege Bryan Kohberger's cell phone was at different times before and after the quadruple homicide took place there in Idaho. Special Agent Tony Imel, a video identification expert, will testify about how he settled on the suspect's vehicle as a white Hyundai Elantra. Bryan Kohberger owned a 2015 version of the sedan. In addition, the Latah County coroner, Kathy Mabbitt, who has been in elected office since 2006, is also listed as a possible expert witness. She issued the 4 victims' death certificates and oversaw the autopsy performed by the Spokane Medical Examiner's Office. Now, Mabbitt has over 40 years of experience as a registered nurse, and the prosecution wrote and works as a criminal defense attorney in Moscow. The filing read that the others, still unnamed experts, are expected to speak to the toxicology results of the 4 students. The victims were each out late in the evening of with friends before the early morning knife attack back in November of 2022 at an off-campus home there in Moscow, Idaho. So now the defense is requesting a delay in the deadline for its own experts because the prosecution was somewhat delayed in providing theirs. Now, as you may recall, the Moscow police forensic detective Lawrence Mowry filed most of the search warrants in the investigation and is listed among the prosecution's likely witnesses. He is one of up to 3 law enforcement members specializing in obtaining and analyzing digital evidence and may be asked to testify. They disclosed that an unnamed crime scene expert specializing in reconstruction and bloodstain pattern analysis will also appear during the prosecution's portion of the trial. In addition, as many as 11 experts related to the Idaho State Police Crime Lab located in Meridian will be called as well. Now, each may speak to the specific lab reports, according to the disclosure filed by the prosecution. According to a recent defense filing, the state's expert witness list is 400 pages. Most of the contents are curriculum vitae or CVs, fancy word for resume for the named experts, but with a few exceptions, including limited details about their opinions anticipated at trial. And so the defense thinks they are not specific enough. The prosecution disputes that. Guess what? A judge will decide if the disclosures are sufficient enough. Now, here's the thing. If the prosecution doesn't provide enough detail in their reports, their experts are limited to it. You can't just get up there and opine on the stand if it's not in the expert report. So prosecution better get it right. Now, Kohberger's attorneys are seeking sanctions against the prosecution for not fulfilling the demands under the Idaho criminal rules, and they ask that their January 23rd deadline to turn over their expert witness list be pushed back. Now, Rylene Nolan, who has worked at the Idaho State lab for more than 20 years, including as a manager of the past decade, is the only one of the group of the state's forensic DNA experts identifying by name in the prosecution's latest filing. Prosecutors wrote that she is expected to testify to secondary transfer, or the process by which DNA can pass from one person to another object or another person. Investigators found the leather sheath for a K-bar knife on the bed of one of the victims next to her body, according to the police. And the Idaho crime lab later discovered a single source male DNA on the knife sheath button. There's a little snap right here, which police and prosecutors have said was later matched directly to Bryan Kohberger. The name and the expertise of the remaining state witnesses remains a mystery to the public. And on Wednesday, according to a public case summary, the Ada County District Judge Stephen Hippler issued an order sealing the full list, and prosecutors and the defense have previously agreed to seal the state's expert witness list. Now, Bryan Kohberger is next scheduled to appear in court before Judge Hippler on January 23rd for a hearing over the defense's efforts to suppress various pieces of evidence against Bryan Kohberger. Remember, ladies and gentlemen, if you don't like the evidence, the defense has to come up with a way to make it go away. You do that through a motion to suppress. That's how it's done. Was it obtained illegally? Was it done in violation of usually the Fourth Amendment? Somebody's right to privacy is normally it. I don't think the motions are going to prevail in this regard, but I am keeping an open mind, as you all should, and let's wait and see what comes out at the motions hearing. Remember, it's going to be all about that genealogical DNA evidence that the prosecution says, hey, we're not even going to use it, even though that was used to establish probable cause. A lot of interesting legal issues not going to be resolved just in the Kohberger case. Whatever happens in the Kohberger case, assuming he loses, it will be a huge appellate issue. Now, Bryan Kohberger's attorneys also allege that the police violated their client's rights against unreasonable searches and seizures protected by the Fourth Amendment, which the prosecution say, no, we didn't. Kohberger's capital murder trial is set to take place there in Boise this summer. And if all goes well, jury selection is supposed to begin on July 30th. Now, obviously, Bryan Kohberger is given the presumption of innocence, but if he is convicted, he could be sentenced to death. Lori Vallow, she was denied. Now, we brought you the hearing of Lori Vallow proceeding as her own attorney last week. Didn't go well for her. The judge seemed very skeptical, and one of the motions that Lori Vallow filed was that she wanted the state of Arizona, the prosecutors in the case, to produce discovery related to her extradition from the great state of Idaho. What does that have to do as it relates to the murder of her former husband and the attempted murder of her former niece's husband? Nothing. And that's what the judge ruled. The court's order is rather quick. In regards to the matter of Lori Daybell, she officially wants to be known as Daybell, but she's always going to be Vallow to me. All right, so we're going to keep it that way, just to keep it consistent. All right. So the court has received the following motion: defendant's motion to order the state of Arizona to produce discovery of extradition, filed December 16th of 2024. The court has also reviewed the state's response to the motion to order the state of Arizona to produce a discovery in regards to the extradition filed January 5th of 2025. The court has also considered the arguments the defendant has placed on the record during the hearing on January 10th of 2025, and the defendant has failed to establish there is any relevance to the requested documents, nor that the disclosure of extradition documents would be reasonably likely to lead to any discoverable information related to the crime in which the defendant is charged. It is ordered denying the defendant's motion. Doesn't go well for Lori Vallow. Now, here's the interesting part. She's representing herself. I'm sure she thinks that there is some sort of big conspiracy to get her back to Arizona, and that's why she wanted to see it. She said in her hearing, when she was making her argument, that she understood that they weren't going to come get her, so why now did they come and get her? Well, it doesn't really matter. What does it prove? I mean, she'll get the bill for the cost of extradition that she'll never pay. So I'm not sure what that is about. It's not going to be some smoking gun. I mean, she's charged with the death of her husband, ex-husband, Charles Vallow, by her brother, conspiring with her brother, Alex Cox. I'm not sure what the extradition has to go to prove the elements of that offense, right? If it doesn't go to prove or disprove the element of the offense charged, it's not relevant. Now, sometimes you got to build the bridge to get to what is relevant, but Lori Vallow failed to do so. We will continue to follow that case because it's the case that just keeps on giving. All right, Luigi Mangione, that's right, the man accused of fatally shooting the United Healthcare CEO in the back, Bryan Thompson, visited a gun range during a trip to Thailand about 3 months before he visited New York, according to some people that were traveling with him as some travel companions. Now, this information regarding Mangione is in TMZ's new series, Luigi Mangione, The Mind of a Killer. It's going to come out soon. Now, the companions claim that Mangione was obsessed with a book titled Hit Reverse, New Ideas from Old Books by Indian author Jash Dolani, and attempted to buy, at one point, some 400 copies. Now, the documentary speculates that Mangione's alleged shooting stems from his frustration over corporate greed, not just insurance companies. So apparently, they comment that everyone thinks this assassination was about health insurance, but Luigi Mangione apparently had a much bigger grievance than just healthcare insurance. Apparently, Luigi's gripe was over corporate greed, and health insurance is just a mere symbol of corporate greed. Now, Mangione obviously faces multiple counts of murder, including murder as an act of terrorism under federal and state charges in New York, and he has some miscellaneous charges in Pennsylvania as well, where he was arrested. Now, like I said, he's been accused of gunning down Thompson as he was walking into an investors conference in Midtown Manhattan on December 4th. Now, the federal charges could carry the possibility of the death penalty. Not going to happen. With the maximum sentence for the state charges, it's life in prison without the possibility of parole. Now, prosecutors have said the two cases will proceed on parallel tracks, with the state charges expected to go to trial first. Now, we talked about this last night on our live show. I want to thank everybody for joining us. Usually the feds, when they think they got a rock solid case, nice and pretty wrapped up nice and pretty with a bow on top, the feds want to go first. But in this particular case, they're letting the state do it, which makes you think they maybe have a problem. Could it be the ID issue? I don't know. Or could it be that they just don't want to have to deal with sending Luigi Mangione, who's developed a fan base for all the wrong reasons, apparently, for, killing a corporate CEO. We're going to have to wait and see, ladies and gentlemen, but it's going to get good. Don't kill a police dog. That's right. So before this guy, Sean Christopher Davis, was killed in a shootout with police on Wednesday evening, he shot and wounded a canine dog belonging to the United States Marshal Service. That's right. The canine that has been named Rocky alerted officers after finding Mr. Davis hiding in a trash bin behind the same Southwest Houston strip center where Davis gunned down a deputy sheriff, Jesus Vargas, hours earlier. Now, when Rocky jumped into the dumpster, Davis shot the canine twice before he was ultimately shot and killed by police officers as well. Now, the interesting aspect here that people have to understand, according to the U.S. Marshals, was that this canine saved lives. So when that canine went in there, he decided to take the dog out. The marshals said that that proved that the canine basically saved the officers' lives around him. Now, in the middle of the chaos, law enforcement officers carried the injured canine to a helicopter so that he could be rushed to a veterinary hospital for treatment. Now, the Houston Police Department said the dog was stable, resting, and expected to survive. Rocky's handler stayed with him overnight and will remain by his side until he is discharged. Don't hurt a dog. I mean, seriously. And let alone, if you hurt a canine dog, police dog, it's like shooting a cop. It really is. And that individual that shot him, he's lucky. He's lucky, I guess, that it ended for him in a dumpster. Next, Alec Murdaugh. What is the status of that appeal? So, the convicted double murderer and confessed fraudster, that's right, Alec Murdaugh, well, his attorneys filed an appeal of his murder conviction with the South Carolina Supreme Court, preparing the legal system and the American public for the next step, which they hope will be a new trial. That's right. On Tuesday, Murdaugh's attorneys, Richard Harpatulian and James Jim Griffin, filed a 132-page initial appellate brief, which combines both of Murdaugh's previous appeals to the South Carolina appellate courts and argues points that pertain to both the 6-week double murder trial held in Walterboro in the spring of 2023 and the state's murder investigation that preceded it. Now, for those who don't recall, Alec Murdaugh was convicted back in March of 2023 of the June 2021 shooting deaths of his wife Maggie and his younger son Paul. During the trial, Murdaugh's attorneys argued that the state's investigation was shoddy and the prosecutorial case was rather weak and improper. And after his conviction, which resulted in 2 life sentences, that there were allegations of jury tampering. It came to light after the former Colleton County clerk, Rebecca Hill, wrote a book. Anyway, Murdaugh announced plans to appeal back in September of 2023 when his attorneys made these allegations of jury tampering against Hill, who later resigned and is now facing ethics violations charges that are going to be heard this year. Now, back in January of 2024, a special court-appointed appellate judge, a former Supreme Court Justice, Jean Toll, conducted a 2-day hearing in the jury tampering allegations before denying Murdaugh a request for a new trial. Now, Murdaugh's appeal asked the high court there in South Carolina to vacate his convictions, life sentences, and reverse Toll's order and grant him a new trial. They cite in their brief, quote, any person accused of a crime, even Alec Murdaugh, has a constitutional right to a fair trial. Totally agree. And when a fair trial is denied, he is entitled to a new fair trial. He is not required to earn it by proving he would have been acquitted had he been given a fair trial the first time. No. The judge's opinions regarding the strengths of the state's evidence against the accused are not substitutes for the presentation of the evidence of that fair trial. The court should therefore reverse the trial court's decision, denying Murdaugh's motion for a new trial, vacate the murder convictions, and give him a new trial. They further suggested that the court should vacate the murder convictions because they improperly admitted, the judge did, evidence depriving Murdaugh of a fair trial and in consideration by the jury was not harmless error beyond a reasonable doubt. Now, here's a couple of the highlights of the appeal. And, you know, I'm pretty convinced that that was Alec Murdaugh's voice on that little TikTok video. But I think he got screwed at trial by the judge who allowed in all that 404B evidence. I think it was over the top. And the case really went downhill from there, plus the allegations of witness tampering. Anyway, here's the highlights. First, Murdaugh was denied his constitutional right to a fair trial by an impartial jury free from outside influences, and the appeal argues that several comments made by Hill, the clerk, a state public official, to the jurors were designed to influence a guilty verdict and to help her profit from her now plagiarized and unpublished book, Behind the Doors of Justice. The United States Supreme Court holds that jury tampering is presumptively prejudicial in a criminal case. The presumption of prejudice is irrebuttable when a state official tampers with the jury during a criminal trial about the merits of the case. And the state cannot rebut the presumption of prejudice by arguing that Ms. Hill's jury tampering was harmless because secret advocacy for a guilty verdict in the jury room during a criminal trial by a state official is a structural error in the trial that cannot be harmless. Next point, the trial court allowed the state to introduce improper character evidence and other irrelevant and unfairly prejudicial evidence that so infected the trial with unfairness as to make the resulting convictions a denial of due process. The appeal goes on to argue that during the trial, the state improperly submitted several days of bad character and financial crime evidence, as well as physical evidence Murdaugh's claims was faulty or unrelated to the case. That's where I think they're going to win. Anyway, evidence of financial crimes, including damaging and prejudicial testimony from sympathetic victims of Murdoch's financial fraud, should have been excluded under Rule 404B and 403. I agree. Hey, if they're introducing 404B, that means they don't have a strong case, ladies and gentlemen. And think about it. All the bad character, he's a scumbag. I get it, but give the man a fair trial. Anyway, the state's theory that Murdoch's murdered his wife and son in cold blood to distract his law firm from investigating alleged financial improprieties is illogical, implausible, and unsupported by the evidence. The trial court also erred by allowing the state to introduce faulty evidence and unscientific experiments, including an experiment made by a police officer tossing a cell phone around his office to replicate a phone owned by one of the murdered victims. The trial court erred by admitting irrelevant and unreliable firearm evidence and by allowing SLED, the South Carolina Law Enforcement Division firearms examiner, to provide irrelevant, unreliable, and confusing opinion testimony. The trial court erred by allowing the state to introduce multiple guns seized from Murdoch's residence when no evidence linked the guns to the murder. Remember how they held the guns around even though they weren't the guns that were supposedly used in the murder? Prejudicial. The trial court erred by allowing the state to introduce gunshot residue results of a raincoat into evidence when no evidence linked the raincoat to Alex Murdaugh. And it's unclear whether the South Carolina Attorney General Office is going to file its response here soon. But anyway, it will be due usually within 28 days. So I expect it here in the next couple of days, which is the reason why we're talking about this. Anyway, Murdaugh continues to serve his multiple consecutive life sentences for the murder in state prison and has also pled guilty and been sentenced to lengthy state and federal prison terms for his financial crimes, in which he stole millions of dollars from his law partners and his law clients. Don't get me wrong, ladies and gentlemen. He's been found guilty. I get it. He's a scumbag. He may be a thief, but it doesn't necessarily mean that he murdered his wife and son. Like I said, it does sound like his voice on there, ladies and gentlemen. But you can't railroad the guy just because you think he's guilty. What have we said before? And I'll say it again. If we, the citizens, the defense attorneys, the legal system, allows the government to railroad a guilty person, guess what? They will start doing it to innocent people as well because they will believe that they can get away with it.